Thanks very much, Jack, and thank you for putting me on first. Unfortunately, I need to leave by 12:30 to catch a flight, and so I regret that I won't be able to be here till the end. But as Jack said, I'm going to talk about the California rules, and I'll also mention the European rules, which together reduce the significance of the ultimate outcome of the litigation challenging the SEC rule, and also reduce the significance of the fact that the SEC rule was significantly cut back between the draft and the final. So in September and October, Governor Newsom signed into law these three statutes that I'll be talking about: the California Corporate Data Accountability Act, the Climate-Related Financial Risk Act, and the Voluntary Carbon Offset Disclosures Act. The third one I'll just mention now, that it requires a great deal more disclosure by both the sellers of carbon offsets and the users of carbon offsets, given the pervasive skepticism about the legitimacy of carbon offsets. And this is designed to make sure that a great deal more information is disclosed about the use of that. You've already heard about the CSRD rule. The California rule laws have generally been seen to apply to about 75% of all the big companies operating in the United States. And the European rules also apply to a large number of the large US companies. So I'm going to compare the California rules and the SEC rules, which you've already heard a lot about and you'll hear more about, and the European rules. So on the left column are the SEC rules, then the CSRD, and then the California laws. And very importantly, as you've heard, the SEC rules apply only to SEC registrants, but both the CSRD and the California laws apply also to private companies. And so there's some very large private companies that have operations in California that have significant carbon footprints. The largest are Cargill and Koch Industries, that are not subject to these kinds of SEC disclosures, but are certainly subject to the California disclosures. As you've also heard, the Scope 1 and Scope 2 disclosures under the SEC are required only if material. The European rule has double materiality, and I think Professor Orts is going to talk to you more about double materiality. California has no materiality requirement at all. So Scope 1 and 2 need to be disclosed in California regardless of whether they're material. Scope 3, as you've heard, isn't required at all anymore by the SEC. It's required in Europe with double materiality. It's required in California without any materiality requirement. All three rules have fairly stringent requirements for disclosure of the use of carbon offsets. All three require certain information about the financial risks, in addition to just quantifying the emissions. And only the European rule requires the disclosure of lots of other non-climate impacts. In terms of when the disclosures will happen, as you just heard, we don't know when the Eighth Circuit litigation challenging the SEC rule will be resolved, and presumably there'll be a new compliance schedule then. The European rules are being phased in. The California rules are to start with 2025 for Scope 1 and 2, fiscal 2025 for Scope 1 and 2, and fiscal 2026 for Scope 3. However, Governor Newsom has suggested that the legislature ought to push those deadlines back. It hasn't done that yet. There are limited assurance auditing requirements for the SEC and Europe. Under California, it's limited assurance scaling up to reasonable assurance for Scope 1 and 2 in 2030. So the details of the California rules have to be worked out by the California Air Resources Board, CARB. And the statute gives CARB until January 1 2024 to issue those rules. There was a delay in their getting the budget. They now have the budget, but it may be that they'll want to push back the deadline for issuing those regulations. Some California legislature received a great deal of lobbying in advance of adopting the statute, and I'm sure that CARB will likewise hear from a lot of people as it adopts its new rules for the California requirements. But a number of the questions that CARB will have to resolve: how big a business has to be before it's subject to the California laws? How much business in California does it have to do? If it's under the California tax rules, it's a very small number. We'll see what happens. How are affiliated corporate entities treated? Do the disclosures apply not only to the businesses operating in California, but also to subsidiaries and parents and sibling companies and so forth? Which of the scope 3 categories have to be disclosed? I'll return to that in a minute. What is the level of detail and certainty that is required? Is it acceptable just to rely on standard ratios, industry ratios, or do they have to be more specific? I'm sure they're going to make an effort to be as consistent as possible with the SEC in Europe. And for the financial disclosures, what future scenarios, for instance, of climate change need to be considered? So as we've heard, there's litigation pending against CARB, challenging the law, led by the Chamber of Commerce of the U.S. They sued in the U.S. District Court for the Central District of California in January. The state has moved to dismiss. The principal theories in the litigation are the First Amendment challenge that it is compelled speech. Now, giving my personal view, I don't understand how just disclosure of quantities of greenhouse gas emissions can be impermissibly compelled speech. And in the financial disclosures, if a company says, well, we don't believe in climate change and we don't think that it causes any financial exposure, they can say that. It'll expose them to reputational risk and other things, but I think they can say that. I haven't found the section of the Clean Air Act that preempts further disclosure requirements. I don't see how the extraterritorial regulation survives the Supreme Court decision in the National Pork Producers case, but the courts will tell us about all of those things. So by far the most controversial part of the disclosure requirements was scope 3. And so let me talk about that for a minute. So scope 1 emissions, of course, are the direct emissions from the company, from its factories and its owned vehicle fleets and so forth. Scope 2 are the indirect emissions, mostly from the electricity that it buys. That's easy because the power plants that generate the electricity all have to report that. Scope 3 is the controversial part, both upstream and downstream. There are 15 different categories of scope 3 emissions. So far as I've been able to tell, no companies disclose all 15. A lot of companies disclose some of them, but because it's all over the lot, you can't compare apples and oranges. You can't compare the scope 3 emissions of one company to another. So in my own view, the disclosure of scope 3 is important because in much or most of the climate impact of most companies is their scope 3 emissions, their upstream and downstream emissions, the material that goes into making what they produce and the shipping of it and the use of their products and other aspects of their supply chain. Understanding the full impacts of a company's operations is useful to investors who care about the climate impact of the companies they're investing in and the potential vulnerability of those companies to the energy transition and to carbon pricing and other regulatory programs. Knowledge of scope 3 emissions is useful to potential customers and employees who care about these issues. And very importantly, it's important to company managers, especially in companies that are making net zero pledges, as many of them are. Measuring the full impact of a company, including upstream and downstream emissions, enables the company to systematically reduce the emissions attributable to the company directly or indirectly. And my own view is that a company that does not measure its scope 3 emissions is demonstrating that it's not really caring about its climate impact. In order to understand the climate impact of a company, it needs to measure its scope 3 emissions. Obviously, there's a lot of double counting and triple counting and so forth, but I would say that that's a feature, not a bug. The purpose of scope 3 accounting is not to come up with some master inventory of overall economy-wide greenhouse gas emissions. We already have that for the most part. It's instead to allow us to understand each company's direct and indirect contribution to emissions. An oil company's climate impact is not primarily the direct emissions from its wells and its refineries. It's mostly the use of its products. Likewise, a motor vehicle manufacturer's primary climate impact is not from its manufacturing facility, but it's from the use of the motor vehicles it makes. So the same gallon of gasoline could be the scope 3 emissions of Exxon and of General Motors. Now, one could say that that's the scope 1 emissions of somebody else, but most of the driving is done by individuals who have no scope 1 disclosure obligations. When any of us drive our cars, we don't have to disclose scope 1. And so it does not get into that reporting scheme. But if we want to fully understand the climate impact of the auto manufacturers and the oil companies and so forth, we need their scope 3 numbers. Because of the importance of scope 3 emissions, it's already required by multiple authorities, and likely more is coming. As you heard, the SEC dropped it, but it is required by the CSRD if material and the new California laws, regardless of materiality. It's also found in proposed amendments to the federal acquisition regulations that will apply to federal contractors. And demands for type 3, scope 3 disclosures are also coming from many other big companies, big investors and others. Climate activists are also pressing for scope 3 disclosures, and these demands will only intensify as the climate crisis itself intensifies. The 9 warmest years in recorded history are the 9 most recent years. And 2023 was by far the warmest year by a wide margin. It now appears that 2024 is going to be warmer than 2023. And this hot summer we are now experiencing is likely to be one of the coolest summers for the balance of the century and beyond. There are similarly large increases in many other indicators. The heat in the oceans, the rate of sea level rise, the severity of lethal heat waves, the severity of wildfires and the smoke they cause, inland flooding. I could go on. These trends are moving us into uncharted territory, into climatic conditions that human civilization has never had to cope with. And the worse it gets, the more demands will be put on corporations to reduce their direct and indirect greenhouse gas emissions, starting with the basic job of measuring their direct and indirect emissions. Much of this sort of reporting is already happening. The big accounting and consulting firms and many others are already working up ways to calculate them. More than 3,500 listed companies are already reporting their scope 3 emissions, according to MSCI. Complaints that this will cost a lot of money to come up with these numbers ring hollow, since it adds only marginally to the cost of that these big firms spend on accounting and consulting and legal services. According to a study that just appeared in the journal Nature, the world economy stands to lose on the order of $40 trillion annually. That's trillion with a T by mid-century as a result of climate change. And so some added accounting costs aren't even pocket change compared to that. Finally, also ringing hollow, in my view, are the arguments that it would be better for Congress to decree these requirements. Of course it would, but Congress will do no such thing. We know that one of the 2 major political parties aggressively pushes back against action on climate change. And much of the campaign finance for that party is coming from the same interests that say that agencies like the SEC and EPA shouldn't do more on climate change without explicit authorization from Congress, authorization that they're working very hard to prevent is never given. So for all these reasons, I think that US companies need to recognize that the requirements to measure and report scope 3 emissions are coming in many places. And in many places, it's already here, and no amount of litigation is ultimately going to stop that. Thank you.
Before you escape, there are many uncertainties overhanging. What's going to happen in Canada, what's going to happen in the US. But probably the biggest uncertainty is what's going to happen on November 6th and what impact will that have. I can't believe that a public corporation facing the challenge of complying with all this isn't sitting back there and figuring out the odds on November 6th and what I do that way and what I do this way. What's your sense of that? How do you see the impact? I'm not getting into the politics, but the impact of a Republican victory on corporate planning.
So I think clearly if the Republicans win in November, the SEC rule will go away either through a new vote or more quickly than that. DOJ may decide to settle the Eighth Circuit litigation by saying, okay, we're going to withdraw the rule. And I don't know if that would require a vote by the SEC or whether DOJ can do it. But clearly there wouldn't be any enforcement of the rule. So that wouldn't happen. But the California rules and the European rules apply to most big companies. And I think that companies are going to have to recognize that regardless of what happens in November, the great bulk of them are going to have to make these disclosures for one reason or another.
Okay, thank you. You stayed within your time, which is unusual for a Columbia symposium. So we applaud that.
So I'll spend just a little bit of time. We've heard about the SEC's climate disclosure rules. I'll just talk a little bit about some of the things some of the differences between the proposed rules and the adopted rules that my clients are happy about, that have gone away, and what perspective we are sharing with our public company clients. Then I want to talk a little bit about the enforcement and litigation landscape that I actually think will continue to exist. And then finally, some practical mitigation strategies that we're discussing with our clients. So with respect to the climate, just the SEC's disclosure rules, I think obviously we talked about scope 1, scope 2, and scope 3 not being part of the rules. I think most of our clients were pretty thrilled with that. Perhaps even more thrilled is that the rules are stayed, and this seems to be sort of the new normal, which was similar to what happened recently with the FTC's new non-compete ban, right? Immediately, you had the Chamber of Commerce and the Business Roundtable and other groups filing a suit, right? So controversial rules come out, and then you have litigation and a stay. But nonetheless, I mean, generally speaking, most of our sophisticated big clients are still preparing, right? They're still we're having conversations about nonetheless at minimum preparing for scope 1 and scope 2 and kind of staying the course. Whether or not that's going to result in immediate increased disclosure, maybe not, but I think what it is resulting in is identifying gaps and setting up controls and thinking about these issues. So I think most of our clients aren't just kind of putting this to aside. They are actively engaging in these discussions, especially because of what we talked about, which is that a lot of the other regimes will continue to, require, in some cases, disclosure without materiality standards and scope 3. The other thing that I'll point out, which is a difference in the proposed rules versus the adopting rules, which is similar as to what occurred in the cyber disclosure rules, was whether or not there would be a requirement to have a director with specific expertise on the board on, in that case, cyber, in this case, climate. That is an element of the rule that was not ultimately adopted. which I think, that piece really caused a lot of consternation, because boards really want flexibility in determining, what is the holistic view of our board, what are all the different areas of expertise and the complexities that we need to, get the people around the table. And I think it also, obviously depends upon whether, you're talking about an investment bank or, Exxon or, oil and gas company, right? So having a one size fits all approach as to who's around at in the boardroom, that was something that our clients also were pleased was changed from the proposing release. And finally, some of the financial elements of severe weather conditions. That was another area of debate. Ultimately, there will be some required disclosure there in the financial statement footnote disclosures, but not in line item SX disclosures. And of course, as we've been speaking today, on materiality and the fundamental, even though materiality is still the hardest question that we advise our clients on, feeling, at least for the SEC disclosure regime, that, okay, we understand this concept, we understand the traditional notion of, the SEC's, the Exchange Act view of materiality, and not looking to the double materiality is also something that was important. About California. So this is just, the professor had a columnar presentation of this. This is a little bit different, and I won't go through this, but this is sort of a disclosure and assurance timeline for a large accelerated filer that's subject to all the various rules here. So the SEC in California, as you can see, without going through this, it is a long. If the rules go into effect, obviously there, some of them are state, and this timeline will inevitably shift, but different timing, different rules, different timing for assurance levels, scopes, and so even though you might argue that lots of companies are already complying, this is a challenge. This is a challenge for large multinational corporations that are kind of playing a game of checkers to figure out what they're going to have to comply with and when. Okay. All right. So shifting a little bit to sort of the regulatory environment. So we've seen a significant uptick in regulatory actions and litigation, both in the US and in Europe, targeting greenwashing claims around sustainability, recyclability, carbon neutral, net zero, those types of things. And then that's across the US and the EU by various regulators. And on this slide are just, some of the representative types of claims, including, false advertising, negligence, breach of fiduciary duties. So, we anticipate that this uptick, will continue over time. And I think that this, and I'm not gonna, guess on whether or not if the administration changes, but I mean, I think right now the thought is that the SEC and the regulators are pretty aggressively looking at this, even though it might not be sort of in the open, but we know, sort of from back channels that several, of our clients that are large multinationals are being, reviewed for with respect to their disclosure claims. Oh, and so one thing, where's the disclosure, right? So where's the disclosure? I think what we are telling our clients is that it is everywhere. It's not just in your SEC filings. It's not just in your sustainability report. It's not just on your website. It's also in, your tweets and your communications, and everything that you put out there is being reviewed for accuracy, for completeness, and for consistency. And that is what we are finding to be the real struggle, is getting, the controls around, multinational issuers to be able to understand what mouthpieces they are out there, and how to coordinate those to make sure that your disclosures are not, inconsistent from one another. So some of the regulatory actions, I'll just touch on one of these, which was in the matter of valet, which was probably the most prominent sort of, high profile recent action that we've seen, where the SEC alleged, securities fraud for false and misleading statements made by valet. They brought charges in 2022 stemming from the company's, allegedly false disclosure that its dams were, met international safety standards. Well, unfortunately, the dam collapsed, killing 270 people, and led to Valet's market capitalization dropping by $4 billion. The SEC complaint alleged that for years the dam didn't meet the safety standards, but it continued to disclose. And this was actually a foreign private issuer, so it was subject to the SEC's disclosure rules, but not, sort of a U.S. company. But for years that the disclosure was inaccurate as to their sort of, regulatory and investor claims that the dams were safe. It was a $55 million settlement, and the SEC's Division of Enforcement, Director of Division of Enforcement, basically said after that settlement that this is just, one of a continuing trend that they will continue to bring these types of cases for false and misleading statements, which he's repeated in recent years. So we've also got, okay, I'll skip this slide because I think, the other thing is I'll touch on plaintiffs' firms, I guess, just for a second. We haven't seen the plaintiffs really so much action around the plaintiffs' firms, and most of the plaintiffs' firms that have been bringing suits have been, sort of small and less reputable ones. But we have seen a little bit, a little bit more progress in here, and some plaintiffs' firms that are a little larger starting to get into the game. And private plaintiffs' firms and NGOs are starting to drive litigation in this space as well. So, put a couple on this slide here, but so, I think the point of this is that you're getting it from the regulators, you're getting it from the plaintiffs' firms. Companies that are incorporated in Delaware are recently facing books and records requests to show their books and records on whether or not the board is actually, reviewing and getting materials on, on targets, on their climate change disclosure. Okay. And then you have the state AGs. So the attorney generals, New York is sort of leading the pack. I'm surprised we haven't seen more from our friends in California. But New York has been pretty active in terms of bringing enforcement actions. I'll touch on the last one, which is the JBS USA Foods action, which actually started out in the New York Better Business Bureau. And that case is now with the New York Attorney General alleging that JBS deceived consumers by claiming that they would be net zero by 2040. Okay. The company's disclosures had forward-looking statements, had safe harbors, had all of the necessary bells and whistles that, we as practitioners tell our companies to include in their filings. What they didn't have is an actual record of trying to meet those goals. So they, their books and records just did not reflect any, essentially any conduct that they were trying to meet their net zero goals. This case is it's ongoing, but if I had to guess, I'd guess it's probably not going to end well for them. Okay, no problem. Last thing, one of the last things we'll mention is the whistleblower regimes. Again, just wanted to touch upon them. This past year was a record-breaking year for the SEC's whistleblower program, and we think it's going to also be used as a method to report things like, making claims that can't be supported in terms of net zero. And then finally, you know, as practitioners and we're dealing with our clients, you know, what are we telling them? We're telling them to stay the course. We're telling them for the most part that you're going to be subject to some of these regimes, no matter what, especially if you're a large multinational. We're telling them to review their disclosures across different platforms, to stay informed on the new regimes, and to do kind of a gap analysis between what is the law going to potentially require and what are you actually doing, and identifying gaps between, you know, between those two things, and setting up the internal controls and the disclosure controls across your organization to be able to meet the investor needs and meet the disclosure requirements, and not just from the regulators, but from, you know, various constituencies, including, you know, employees, NGOs, and others. So it's a wonderfully challenging time, and we're going to continue to keep track.
Let me ask you one question
Sure.
before you sit there.
Sure.
Now, your clients are also concerned about this new behemoth, California.
Yes.
An organization with not much staff, not much experience, not much guidelines. But they said, we have to really pay attention to this because, gee whiz, there's so many reasons why it might get struck down. What would be your answer to that kind of question as of our current vantage point?
Again, most of our clients are still preparing. I do have to say, interestingly, we have had a few clients ask us, well, what if I don't comply? And in California in particular, the monetary penalties are so low. And so the real risk there is just, you know, is for the most part optics and reputational rather than monetary and enforcement.
Well, you don't have some of the defenses. The SEC has to worry about the West Virginia case and this idea that new policy initiatives require Congress. That argument doesn't apply to the state of California. So anyway, thank you very much, and we'll keep on. Our next guest is going to be Eric Orts, who's a professor, he's a law professor, but he's a professor at Wharton's Business School, and he's an expert.
Here's a quick outline of what I'm going to talk about. First, an overview of what, which we haven't had yet, of what I call the ESG smorgasbord, what it includes. The next main question of what actually are we trying to do? What's the purpose? Is the purpose just financial returns? Is there another purpose? ESG sounds like it's another purpose, and I'm going to show you that the origins of the idea did include something else besides shareholder returns, as we were discussing earlier. But then who decides? How do we decide what the purpose of ESG is? The origin story, which some of you may know already pretty well, comes from the UN as well as institutional investors. So has the interest in the UN in actually solving some of the problems we're talking about dropped out now? Are we only talking about what the motivations of institutional investors are? A word we haven't heard yet, speaking of history of Columbia, one of my favorite seminars when I was here was taught by Harvey Goldschmidt, who had some experience with the SEC, and he taught a course in corporate responsibility. Do we still teach a course like that? Some places maybe we do, but how does it relate to ESG? We haven't really talked about that yet. I'm going to come back to the materiality issue and double materiality. And then last, I'm going to try to ask the more general landscape question. What kind of law is this? What are we really trying to do? And I'm going to suggest that we need to go beyond ESG. ESG may work for certain purposes, but we have to think about a lot of other kinds of regulatory approaches. I think California is one of them, and we'll come back to that. Okay, and a few conclusions. So just some quick general credits. Some of the ideas come out of a conference we had with Wharton and Luis in Rome around this time last year. I'll make a shameless plug for the book that's coming out of that conference called The Ethics of ESG. We haven't heard the word ethics, I think, so far either. That's co-edited, but with some colleagues. And then I teach a course that's related at Wharton, and then also here at Columbia as part of the executive LLM program in the summer. Okay, the ESG smorgasbord. You can't read all of these, but there's a lot of different things that everything is in the pot of ESG. Even at the beginning of the wave of interest and the accounting firms, the law firms, businesses ramping up ESG, there had been critiques that were being made, not only from the political side, which we've heard about, but also the academic side. I would suggest that you Google a colleague of mine at Wharton, a former colleague, I should say, David Larker, who was a very prominent accounting professor at Wharton. He was now at Stanford. He's written a number of co-authored pieces saying, wait a second, this doesn't make sense because you're trying to measure too many different things. There's a lot of vagueness in how we are defining these things. There's a lot of openness of how any company, different kinds of investors are going to define these issues differently. The idea that you can rate companies with all of these different variables is significantly problematic. And just to throw one example out there, where are you putting generative AI? It's not on the list yet. It obviously should be on the list. Is it E? Is it S? Is it G? Is it all three? So one of the main questions to get to is the purpose of ESG. And we've already heard about materiality and the fundamental distinction and the separation between how the Europeans are thinking about materiality, which is not only financial materiality, or which we heard somewhat disturbingly, I think, from the SEC, a focus only on pecuniary materiality. The Europe is clearly thinking about other kinds of materiality. What effect is this actually having on the environment? And they put together both financial and impact materiality to get this idea of double materiality. So we can talk more about this. Here's a general sketch of materiality and double materiality. You've heard about this a little bit, and I think a number of you already are familiar with it in detail. But here's one example. The stock market is booming, in the United States at least. That's an example of the issues with respect to climate or whatever are not having a big effect on the pecuniary returns that we're seeing. At the same time, as Professor Gerard just noted, temperatures are also rising, and they're not stopping. With respect to the climate, as well as other kinds of issues, the impact of the economic system is having a very heavy effect on the environment. It's having an effect on other issues as well. And this is why you have forces in Europe, at least from a substantive normative point of view, pushing for let's measure these issues too, and let's include that in what the purpose of a business is. So you have this idea of ESG, who determines the purpose? Two leading candidates are first the governments, and we've seen that in Europe particularly, but now also California and to a lesser extent the US Congress and the SEC, or is it the investors? The investors who set the voluntary standards, and a lot of the ESG standards have come out of the interests of investors. The idea there is, yes, we agree that ESG identifies these various factors, but we're going to put it into terms of pecuniary materiality. That is the mainstream view of the Wharton School's ESG program at the moment, that ESG is understood as financial materiality, not these other kinds of concerns that we don't want to worry about. But there's a lot of other interests that are involved here in setting up what are the purposes of ESG. A couple of scholars recently talk about the ESG stewardship ecosystem. You have international standard setting bodies. You have lots of different interests. You have academics that might sometimes have an effect, et cetera. So really, it's an open question. What's the purpose of ESG? It's open. Let's go to the origin story. If we're originalists, I'm not a constitutional originalist, but if we're originalists and thinking about where did ESG come from? Well, it came from Kofi Annan saying, we want institutional investors to do something to help us solve these global problems that we're facing: climate, wealth inequality, et cetera. And there was a global compact agreed in 2000 that said the responsible corporate citizens show that business can be part of the solution to these kinds of problems is what we want. And there was a series of reports that many of you are probably familiar with called the Who Cares Wins reports that were issued from 2004 to 2008. A number, and I list here, of the endorsing institutions were big institutional investors that were involved. And their reports, if you read them today, different people read them differently. Some read them and say, oh, this shows that institutional investors are primarily concerned about pecuniary materiality, as we use that term. And post-Great Recession, I think you've had a turn so that everyone is kind of lining up, at least on the US side of the equation, to say financial materiality is what we're talking about here. I'm just going to quickly list, in the interest of time, different motivations of institutional investors. It's already been noted that Professors Coffey and Professor Gordon have talked about systemic investment strategies that would help to explain why institutional investors care about this. It is an economic risk to the world. And if you are a universal investor that cares about your long-term returns, at least, you're going to be hit if there's no solution to something like climate change. There could be other motivations. Maybe it was altruism that brought that. Maybe that's not a terrible word to even use in a business school context or a law school context. Maybe it's avoidance of government regulation. It's often been the case in the past that informational regulation is used as a compromise. We don't want real pollution regulation, but why don't we just disclose some information if you guys will be happy with that? Maybe that will have an effect. That's at least what Tariq Fancy, a BlackRock whistleblower, alleged. There's greenwashing cases we now know where people are trying to sell ESG funds, but what they mean by ESG is a lot different than what investors who are buying an ESG fund mean. And so, and there could be some other issues as well. All right, let me introduce the idea of corporate responsibility here very quickly. It could be that what ESG is old wine in new bottles. Business ethics is cyclical, and we might be in a new cycle here where business ethics, corporate social responsibility issues are coming back because we have a huge issue that is hitting everyone, namely climate, but as well as some other issues. And therefore, we see a cycling back of some of these old ideas of corporate social responsibility of the kind that I took a seminar here about a while ago. All of you probably in the room are familiar with the Burley and Dodd debate. And in these terms, if you think about stakeholder theory from the business ethics literature, ESG is a new kind of instrumental stakeholder theory. That means stakeholders matters, the criteria of ESG matters only if it is going to affect the bottom line, if it's going to affect profits, et cetera. Otherwise, we aren't worrying about that. The European double materiality standard is different, and it is a version of what used to be called, and I think in some circles still is taught as normative stakeholder theory, where it's you actually do have to take care about the interests of other groups, because you really do. You have to care about employees because they deserve basic dignity. You have to care about the environment because we all have to solve the problem that we're facing. So materiality revisited, we already heard about the traditional standard. I think, and this is similar to, I think, position Professor Fox and Professor Gordon were pressing against what appears to be the SEC's current position, that the old standards of reasonable investor should be big enough to include issues like the climate. Why is it unreasonable for an investor to really care about what a company they're investing in is doing about an issue that affects everyone? I think you have a changing standard. Some of my students, I'm afraid even executives ones now, accuse us, I'm at the tail end of this, of the boomers not understanding what is reasonable from the point of view of younger investors, where younger investors really care about these issues. So financial materiality or pecuniary materiality, I think we can include ethical materiality that includes climate, that includes biodiversity preservation and human rights. 2 minutes, I'm good. And that we should include these in a general unified standard of what is a reasonable investor and what does a reasonable investor think is part of the total mix of information. I think that these other kinds of issues should be included, and many investors, as we also have heard, are already including it. They're already demanding that these kinds of factors be included. One quick suggestion for compromise is that the ISSB's definition of materiality, I'm not going to read this, but just focus on a couple words. recommends that we think about what are the entity's prospects going forward. I think that's a relatively open-ended term. There are ways to think about how you can put the two materiality standards together. Reasonableness is a pretty large word, but what the entity's prospects are, not just how much money it's going to make in the short term or even the long term. And then also, who are the primary users of the information that are in the financial report. So it's possible that the ISSB, which is an international organization, is affecting the European standard, maybe taking them down a little bit of a step, and they may also be influencing the US standards over time. In this respect, the ISSB, which has close focus on financial materiality, is working together in a new collaboration with the GRI, which is looking primarily at impact kinds of issues. Okay, I only have 1 minute left, so I'm just going to say real quick, what kind of law is ESG? I think it is a kind of voluntary self-regulation. I'm going to make an argument that voluntary self-regulations basically don't work very well. If it's supported by law, as you see in California, the EU, maybe to some extent the US and the SEC, maybe it will work, but there's lots of other kinds of regulatory approaches that we could pick from, and it's not clear that only ESG is the one to pick. And lastly, this is an idea of like there's lots of factors that we should apply to think about how we select a particular kind of law or legislation. And there are some sources of ESG backlash that we see that we can get into maybe in the questions later. Okay, so I'll just skip. I basically will skip over the last conclusions. Thank you.
Thank you very much. I am being a little grouchy in this panel to stay within their time. That's so I can give time for Chad to wrap everything up. I told Chad that she is the ghost of Christmas future. Everyone else is being where we are now. Chad's going to tell us the future, how it's evolving, what new patterns are emerging. The future, how it's evolving, what new patterns are emerging, and the floor is yours. And Chad has his own organization. He's the Third Economy, but prior to that, he has a long background at places like BlackRock and others. Okay.
Thank you. Thanks, Columbia. Thanks to our sponsors and to all of you for being here. As Professor Coffey mentioned, I'm going to take a lot of the themes that we've been hearing from our other speakers, and Eric did a great job of teeing me up. And I'm going to apply it to what I see happening right now with institutional investors and what I see happening with companies, both private and public, and give you a little bit of a crystal ball into what I see for the future. There's basically three themes. I'll give you the punchline right now. Strategic stakeholder engagement. So both investors and companies are really thinking about how they're engaging with different stakeholder groups with such diverse sets of interests. They're going back to basics, G, governance, and financials, and good quality fundamentals. And they're moving away from the hot topics at E&S. And they are what I would call waddling to the middle. And waddle is an intentional term because it's a little bit faster than a crawl or a walk, but it's definitely not a run. And it's a little inconsistent like a washing machine because of all the different stakeholders that are pulling them in all these different directions. So safety in the pack is definitely one of the themes of what I'm seeing right now. I want to set some definitions for you all. Basically following on Eric's point, ESG is so often misused. So back to critical thinking, we all need to be reading and listening with a critical ear on what we're hearing from the source. ESG itself, in my mind, is really an analytical model to help us understand risk and opportunity. So how are these factors either going to lose us money, risk, or how are these factors creating opportunities for us to invest in, to make money? And not everybody loves that definition of ESG because a lot of people think about it as impact investing, consequences, intentionality. How do we achieve other goals and objectives beyond financial return? And some people confuse it with values-based investing, morals and ethics. So I use an acronym called VIA, the Way to Understand Sustainable Finance, VIA. It's values, impact, and analysis of ESG. And I use analysis intentionally because I want to reinforce ESG should be integrated into financial analysis, that it's a financial tool, back to materiality. So VIA, the way to understand sustainable finance, it's really three tools: values-based investing, impact investing, and good financial holistic analysis that allows us to use these tools of sustainable finance. So how are institutional investors using these tools? How are companies using these tools? And what does the future hold? Institutional investors are pulling back. They have been hit hard. The politicization of ESG is somewhat their own cause. They have not been consistent in their use of these terms. You go to one website, it defines ESG this way. You go to another website, it talks about ESG and impact like they're the same thing. Well, this is problematic. If you're an investor and you want to buy a mutual fund or an ETF, you should be able to get your can of ingredients, your label, compared between State Street, BlackRock, Vanguard. That's really hard to do. The SEC has identified that's a problem. They've put in some rules. So that's improving. We're going to get more clarity. People are going to start to use these terms in more consistent ways. That's a good thing. But because they haven't historically done that, now institutional investors are on the back foot. And you're not seeing them talk about ESG anymore. You're seeing them get back to basics. You're seeing them talk about governance, basic financial fundamentals. We're not seeing the launching, the innovation around mutual funds and ETFs that we had in the US in the past. So there was a big push to create product, low carbon ETFs, women-only mutual funds, not so much anymore. We also saw a lot of assets running into those types of products. Well, the assets have remained relatively stable. We haven't seen huge withdrawals, but we still don't have the innovation happening. Different in Europe, still innovating, money still flowing. Back to all the reasons why, as have been discussed today. Another thing, the voting piece. So institutional investors, when they think about sustainable finance, they use that to either make better investment decisions or to inform how they vote, right? The idea is we can use these tools to create product for our clients and make innovations that are going to bring assets into the firm, and then we want to make money on those assets that we bring in. Well, what's happening now on the voting side is it's the same kind of pullback. It's back to basics. I would also posit that one of the reasons why you're not seeing the institutional support for shareholder proposals, E&S in specific, like we have in the past, is the really good E&S shareholder proposals tie those factors to the financial. A lot of the proposals that we're seeing today are impact-oriented or moral or ethically driven. That's not how you're going to get a big mainstream investor to support your shareholder proposal. You have to tie your shareholder proposal back to financial value, really ESG in its purest sense, if you want to get support. So it's not just that investors are pulling back because of these external pressures, but it's also that a lot of the shareholder proponents are not very effective at the proposals that they're writing. And hence we end up with this dynamic where a lot of people are trying to get the proposals removed from the ballot. So that's a little bit of what's happening in the institutional investor space. In terms of corporates, the main trend that I see right now, back to waddling to the middle, is an unintended consequence. So I think that the SEC has a very well-intended rule, and most of those in the institutional investor community are supportive of more disclosure and comparability. Those are great things. But what's happening is what used to be voluntary disclosure is now becoming regulatory disclosure. So that means more attorneys, that means more financial control functions are getting involved. That is, in my view, chilling innovation. What's happening is companies are afraid I'm not going to put my neck out there. What's somebody else doing? How do I keep what my company is disclosing in the pack with everybody else so that I don't get in trouble? So I think that's an unintended consequence of a very well-intended SEC rule. I also think that companies are getting back to basics as well. There has been a tremendous focus on disclosure and regulation. But really, what companies need to be thinking about are these other stakeholder groups. And how do we use these concepts of sustainable finance to build better companies, to innovate, and to create better products, to make sure that we can withstand the test of time throughout market disruptions. So a lot of companies, those that are really deploying these concepts effectively, are taking this opportunity to really think about what are the different stakeholder groups, what are their areas of interest, and how do we align our sustainability program with those different areas of interest? For example, employees, back to Eric's point, there's a growing recognition that the younger generation, those graduating from school now or recently, want to work for a company that has values alignment, the V in VIA, that has meaning, morals and ethics in how they run their organization. So how do you, as a corporate, convey the meaning of somebody's job in your organization to your internal employees? Supply chain. We've all seen the impacts of COVID on the supply chain and how important that is to ensuring that companies can survive financially. Well, one of the biggest drivers right now aren't institutional investors or regulators, but it's customers and it's suppliers. Have you heard of EcoVadis? So many companies have to get an EcoVadis score to continue to do business with others in their supply chain. It's become a very strong driving force for corporate behavior. You've got to have EcoVadis Gold to be in our supply chain. So supply chain is becoming a really big driver of sustainable behavior. We've also got customers themselves. How do we sell products to a changing demographic of a younger generation that is starting to care more about how the products and services that they produce are produced? So the corporate impact of all of this is a big focus: regulation, disclosure, but also a distribution of how their sustainability program can be communicated to these different stakeholder groups so that they can use sustainability as a tool to not only convey their effective use of goods and services in producing whatever it is that they are, but also to convey all these other benefits to all these other stakeholder groups. So when I think about the three main themes, it's this strategic stakeholder engagement, taking your sustainability story and pivoting it strategically to each different group, using different frameworks for each group. It's the back to basics, it's the G, it's the financial, the fundamentals, and it's the waddling to the middle, the safety in the pack, the how do we not get our neck too far out because we don't want to get called out for doing something that we shouldn't be, but we don't want to be a we want to make sure that our scores from all these different rating agencies keep us in the safe zone. So what is my advice and what do I see in the future? So for institutional investors, define your terms. Make sure that you're using definitions that are consistent with the rest of the market so that investors in your mutual funds and ETFs can compare across them. Two, think about how do you use sustainability to make better investment decisions and better voting decisions so that you're incorporating these concepts into this financial relevance of your investing. And then think about innovation and product and service opportunities and how do you create mutual funds and ETFs that are going to resonate with a younger generation of investor that's growing up and is going to be inheriting wealth. When I think about my advice for corporations, TCFD, back to all of these global regulations, TCFD kind of hits on most of them. I think we're tracking like 60 globally right now. They all have different components of TCFD. So if you're a global organization, you want to use that framework to your advantage. Don't just think about regulatory compliance, think about innovation, think about how you use sustainability to make your company more financially valuable. What are the macro trends that create white space for you to innovate your products and services in? And lastly, for us as individuals, what can we each do? Well, first of all, we should be thinking about these concepts of what are our values? What impacts do we want to have as we deploy our capital as individuals? And how do we use the analysis of ESG in making ourselves more financially sustainable? So ESG is not going away. It's here to stay. The train has left the station. But I see it like a stock market chart. It's a general upward trend with ups and downs as we go.
Thank you. Now, I have been obnoxious to our entire panel, to save just a few moments for question and answer and for comment across the panel. Let's see, I had questions planned, but we have so little time. I want to ask the audience. You've been sitting here, you must have a question by now. So raise your hand if you do, and come on, raise your hand, or we'll go back to the first year of law school. I'll call upon you. You don't want that. Not prepared. All right, thank you. See, threatening to call on people always works.
Well, I'm probably the only non-attorney in the room, so I figured I should speak before I'm called on. I work for a private equity firm, and I'm the director of ESG.
Do you want to direct to any specific person?
Oh, it can be for the whole panel. So I think about this in terms of our portfolio companies, but also the risk that we have as investors, right? So I'm just curious if, I really resonate with the comments of people are trying to stay in the middle, right? And no one wants to be ahead, no one wants to be behind, but let's not disclose too much, right? Let's not talk too much. So I'm curious, in anyone's experience, I think sometimes when you see these regulations, they're aimed at certain kinds of companies, and I understand why, but it leaves a lot of companies out of the dust, leaves a lot of companies feeling like, oh, that isn't me, or, right, we don't have quite as impact as A, B, and C. Do you ever see a place where regulation or laws might be more sector-specific, or might meet companies in certain ranges? I don't know if there's other examples of that in the law that might be able to make ESG regulation more targeted, and then therefore make companies feel like, the action is more specific to their company, makes more sense to them, and can reach that state of innovation instead of taking it from a place of compliance.
Yeah.
All right.
It's-
Well, Chad, this is sort of, okay, well, Eric, you go first.
Well, these work, yeah. I have a quick recommendation, and that would be to check out the ISSB has standards that are coming out that are specifically sector specific, and or they are sector specific. And one person in particular to reach out to is a former Wharton student who is named Elizabeth Seeger, who's on the board at ISSB, and she was, I think, formerly at KKR. You know her already? Well, ask her. That's the person I would go to answer your question.
Other comments?
I would echo ISSB as achieving that sector orientation that you're mentioning, but that's not how it's really built into the law, right? But that was one of the things I wrote in one of the how many thousands of comment letters to the SEC, was that when they were thinking about climate, they should rely on some sector orientation.
Any other questions out there? Let's get this side of the room to contribute. No hands going up. I thought I saw it. Just scratching your glasses, or you're moving? Well, come on, we got to have a little bit more. All right, I will frame a question for the panel. Where do you think things will be, not in the indefinite future, but in about 10 years? Where we are now with continued debate, or will there be any consensus that you think will develop over the next 10 years, regardless of political outcomes? This is the future, Chad. I'd like you to touch that question.
Well, I know what I hope they will be, and that is that for climate, and specifically, I hope that we're spending more time thinking about action and less on reporting. And even if you think about those that are leaders in reporting right now, they still are weak in the strategy and target setting. Where most of the current reporting is happening, even if it's TCFD aligned, it is in the measurement and the governance, which is great. And now that we've got the control functions coming into place, they're going to make sure that those measurements are more accurate, which is exactly what investors need. But where I see the climate community moving is how do we take what we're measuring and actually affect change? How do we reduce our carbon footprint? So that's where I hope we are in 10 years.
Now, forcing carbon reporting, will that encourage that or will that delay it?
That's a great point. And part of my concern is it may delay because there's so much time and energy spent right now on compliance and fighting over how are we going to do this, that we're kind of taking our eye off the ball.
Lula, you've been nodding your head at least a little bit while he's been speaking. Let's get your point of view because you're the most in touch with your clients.
No, I agree. I mean, I think I'd like there to be, I almost like how you said, your analogy with the stock market. I think I think especially in climate, there will continue to be consensus built around the issues, but as we progress, I'm not sure it's total agreement, but I think there will be, greater and greater consensus. And I think, private ordering through, various stakeholders, even aside from the regulators, I think will continue to, push that along.
Eric?
Yeah, well, I think that's a great question. So I think there's a couple answers. One is I'll channel Professor Gerard, who I think would agree with this, and that is that the climate problem is only getting worse. And we may not want to think about it. It's sort of like thinking about death, but it is going to kill a lot of people. It's going to get worse before we start to turn the corner on it. I think we can turn the corner on it. So as it gets worse, as you have mass heat waves that kill probably thousands, if not more people, you have a consensus building. This really is a serious problem.
It's 110 in New York.
Yeah, well, yesterday it was the all-time high in Philadelphia. And that's, there were all-time highs hit everywhere, across a lot of places across the, so I think one question goes to, I know a theme that Professor Gordon has raised, and that is who will win the battle between the petrostates of the world who don't want to change and don't want to leave a lot of the oil and gas in the ground, and that includes the U.S. and some unlikely bedfellows like Russia and other countries, and they're generally attending tendency toward authoritarianism. Or will there be a democratic coalition that may be led by Europe, maybe by the United States if there's a shift? I think many younger people care about the climate. And I think you're also, on another optimistic note, I think you'll see more and more attention not only at law schools, but at business schools. And I see that now at Wharton, where there are a lot of very smart people who are thinking about how can we actually solve this? And how can we have businesses to the previous point, that we actually solve the problem and have action solving the problem. We don't just think about how do we report about something.
All right, I'm going to give, pursuant to tradition here, the last question to Professor Gordon, and I'm also going to tell him this panel ends in 2 minutes.
This is, in a sense, a comment and a question to whoever wants to respond. But in terms of the 10-year horizon, the political constraints, I think, are the most important ones. And in that regard, think about this. So both the United States and the EU are planning to limit the importation of low-cost electric vehicles, and solar panels from China to the US and the EU. Presumably because of the cost US jobs and European jobs. But I have yet to see an estimate of the foregone greenhouse gas emission costs of what will be the postponement of the transition from, from internal combustion to EVs, right? So that, I mean, yes, there is going to be employment issues in the United States and Europe that motivate, presumably, the tariff policies, but it's also going to have greenhouse gas emission costs in the sense that, if EVs were $10,000, the transition from cars to them would be really fast, and there would be enormous savings in terms of emissions. Putting aside, how one balances all of these things, one can't help but be pessimistic about the seriousness of which the climate change issue is being faced if the question is not even being asked in terms of what is the cost of the policy of doing this in terms of the emission reduction on which the climate change measures depend. Another pessimistic.
Well, not a second thought. We're now officially overtime. We've now done our full length.
Okay.
Anyone want to
Question.
respond to Jeff Gordon in 30 seconds? All right, we are overtime, but I want to thank the panel. I want to thank you all. And,